This is, as others have said, a miscellaneous provisions bill. It touches briefly on a broad range of unrelated issues, which have only one thing in common, in that they're all under the purview of the Department of Justice. But it doesn't deal in any detailed way or systematic way with any of these important issues. There's nothing wrong in principle with that approach, where the resources of the Department and the Oireachtas demand it, but it is a piecemeal approach, and often I know from experience that things are thrown in when you have a vehicle, sure, what's on the table that we can all add in, and some things get through without proper and detailed scrutiny. So I'm going to just address two of the issues in the bill, while my colleague Deputy Nash will speak on the pensions issue. First then, the Court of Appeal is currently composed of a President and 17 ordinary judges. This bill will increase the maximum number of ordinary judges to 18. The increase follows the establishment of the Tribunal of Inquiry relating to the Defence Forces, to which Ms Justice Anne Power of the Court of Appeal has been appointed. This tribunal will do vitally important work, but will inevitably take a number of years to complete its work, and I wish Ms Justice Power and her tribunal well in that important task. A judicial planning working group was established by the Department of Justice in 2021. The current Taoiseach, then Minister for Justice, brought its report to government in January of last year. This was on foot of a programme for government commitment to establish a working group to consider the number of and type of judges required to ensure the efficient administration of justice over the next 5 years. That really important report contained over 50 recommendations. Chiefly, it recommended the appointment of a significant number of additional judges before the end of this year, 2024. Most significantly, the working group recognised that the Court of Appeal and the High Court had secured additional judges in recent years. There had been no increase in the number of judges in the district and circuit courts for almost 10 years, the decade which of course mirrored the highest growth in population in our state's history. According to a recent Council of Europe report, Ireland has the lowest number of judges, 3.27 per 100,000 population in Europe. The European average is 17.6. That report showed that Ireland's spending per inhabitant on courts was €31.10. The European median was €45.53. So there can be no doubt, Lascancora, that our judiciary is undersized in relation both to international standards and to the demographics of modern Ireland. I think it's worth quoting the working group's chief recommendation in full. A significant number of additional judges will be needed over the next 5 years if access to justice is to be provided in a timely manner, and existing backlogs and excessive waiting times is to be addressed. The working group recommends that a phased approach be taken to addressing judicial resourcing. It recommends that 44 additional judges be appointed between now and end 2024 in 2 phases. Phases 1 as soon as practicable, and Phase 2 subject to a satisfactory review before the end of 2024. Additional numbers in further phases should be determined by a review in 2025 of judicial needs. End quote. So we were to start last year with an additional 44 additional judges appointed in 2 phases before the end of this year. In fairness, Phase 1 seems to have been achieved, but there was an increase in the number of judges appointed last year, amounting to the first 24 of the 44 promised. But we legislated in May only for the Phase 1 increases in numbers. If the Minister will have to return to the Oireachtas for a second act if she is to implement Phase 2, and if she is to remain on course, she'll have to do that this year. The working group had recommended that before additional judges in Phase 2 are appointed, there should be some form of impact assessment with appropriate metrics. The Minister informed the Dáil in April that work at that stage was underway to conduct the assessment. So is the Minister confident that she can complete her impact assessment and bring it to government, together with bringing draft legislation for the Phase 2 appointments in time before the end of this year. I hope that the increase in numbers of the Court of Appeal does not turn out to be just a once-off measure, and that there will be time to implement the recommendations of the Judicial Planning Report in its entirety. I think it's important to note that the Court of Appeal should be getting in total 4 additional members, and the High Court 12. The District Court and Circuit Court should be getting 14 additional judges. So far, I think they've received something like half that number. It's been stated that many times, that litigation in Ireland nowadays can only be resorted to by paupers or millionaires. I think one High Court judge said, a retired High Court judge said, actually billionaires at this stage. And that's true, certainly, of litigation in our superior courts, which must deal with the complexities of constitutional and administrative law, judicial reviews, planning, immigration, and so on. Meanwhile, the lower courts do very much the normal everyday work that touches on the lives of most citizens. They're still overworked and understaffed. So if judicial numbers are to be increased again before this year's end, then the district and circuit courts cannot be left out. They should be prioritised, in my view. As regards the amendment to the Judicial Council Act, the Minister referenced last April's Supreme Court decision in Delaney. The judgment in the Supreme Court in that case upheld the validity of personal injuries guidelines issued by the Judicial Council, but only because the guidelines had been endorsed by subsequent legislation passed by the Oireachtas. It seems that had that endorsement by us not come about, then those guidelines would have been found invalid on the grounds that a body such as the Judicial Council is not authorised to make law, and it purported to do so. So the guidelines are part of the law insofar as our courts are concerned. They're bound to have regard to them and can only depart from them for stated reasons. This bill will deal with amendments to the guidelines, which I understand are pending. It provides that any amended version of the personal injuries guidelines adopted by the Judicial Council must be approved by the Houses of the Oireachtas. But while future personal injuries guidelines can now be safely made, or will be when this legislation is enacted, the bill says nothing about sentencing guidelines, which is the other major reform that has been undertaken by the Judicial Council. As you know, the Judicial Council has 2 committees, one to produce guidelines on personal injuries, the other on sentencing. It may say something about our priorities, or maybe even the effectiveness of the insurance lobby, that the Judicial Council was given a statutory deadline to produce the personal injuries guidelines. The deadline was met, and the guidelines have been published and were challenged, as I've said, on constitutional ground. The work of the Sentencing Committee is harder because of the dearth of information. We need to collate information on sentencing. That work is a complex body undertaking that needs to be supported. And I would ask that the Department of Justice, or perhaps the Court Service, would undertake that work in conjunction with the Judicial Council and the Sentencing Committee of the Judicial Council. If the criminal courts are obliged, as Section 92 of the Act provides, to have regard to the sentencing guidelines, then they need to be approved by this legislature. Otherwise, the Judicial Council will stand accused of making law without the approval of the Oireachtas. So we need to ensure that the really important changes that are going to be made to ensure uniformity as far as practicable. Now, every cases stand alone, obviously, and judges have freedom to act, but there must be a commonality in terms of sentencing, and people must understand that they can't go fishing for different court decisions, that there is a commonality, and that's the whole idea behind, or one of the ideas behind, the Judicial Council. So I'd ask the Minister when she intends to bring legislation to us to give the same underpinning to the sentencing guidelines that will be adopted, as she has done with the personal injuries guidelines that have been adopted. And These things, I think, need more teasing out than simply to be put in to a miscellaneous provisions bill that have a broad range of issues that each deserves individual scrutiny.